Thank you for joining us here today. My name is Ian Scott, and I am the founder and managing partner of Scott Legal. Today, we are going to spend some time going through different options to move from a visa, a non-immigrant visa, to a green card. So this would be applicable to someone who was on, for example, an E2 visa or a TN visa or an L1 visa or an H1B visa, or maybe on a student visa, an F visa, or even someone that was in the United States on a tourist visa and looking to move to a green card. And we'll go through the various green card options. Now, a few things before we get started. So one is that we will be just touching on the green card options. And for each of these green card options, there could be and is a separate webinar, which goes over the green card category in much more detail. So for example, when we talk about national interest waiver, we have regular webinars on national interest waivers. So we will just be touching on the various green card options. The other thing to let you know is that we're going to send you a few things after the presentation. So one is going to be this PowerPoint that we run through. This presentation is being recorded, so we will also send you a link to the recording so you can look at sections that maybe you missed or wanted to get clarification on. We'll also send you a consultation link where you can set up a consultation to find out more about any of these visa options. And then finally, we'll send you some guides for each of these options that we talk about. We also have a number of guides, so we'll send you a link where you can download these comprehensive guides. And to the extent you have questions throughout the process, please feel free to either add them to the Q&A or to the chat. We will get to all questions, no problem with that. We may not get to them right when you add them to those places, but we will save time at the end of the presentation for questions. So great, so without further ado, let us move on and start the presentation. So first and foremost, before we kind of get into the detail of the different green card options, I just want to talk a little bit about the way green cards work in the United States, because it is very different from the way that they work in other countries. A lot of countries have what's called a points-based system. So you may get points for education, you may get points for your age, the younger the better in this case. You may get points for speaking the language, how long you've been in the particular country. All of those things might get you points. Then when you get to a certain number of points, you're eligible for permanent residency, which is basically what a green card is. Now, this is very, very different in the United States. The system in the United States doesn't take into account really any of those factors. In particular, it doesn't take into account how long you've been in the United States. You could have had non-immigrant visas for 20 years, and that's not going to have any impact with respect to your ability to get a green card. Instead, what they do is they're just a list of green card categories, and if you're eligible for them, you can apply. And the eligibility is never based on things like how long you've been in the United States, et cetera. They just have a set of eligibility criteria, which we'll go through during this presentation. And if you are eligible, then you can apply for the green card. So now there are more green cards than what's on this slide, but we're going to talk mainly about the green card categories here because they are the most common. And green cards are really broken up into a few categories, but two main categories are family-based green card petitions and employment-based green card petitions. And family-based petitions are further broken down into immediate relative and preference category, and we're going to talk about those when we get to that point of the presentation. And then employment-based green cards are broken down into 5 different categories, EB1 through EB5. The only one we're not going to talk about is EB4, which is a religious-based green card, and our firm doesn't do those. It's a very, very highly specialized area. But we will talk about EB1, EB2, EB3, and EB5. So all of those we will actually go through. So let's talk first about the family-based green card. So we said immediate relatives was one category. Immediate relatives really isn't the way we generally think of immediate relatives, because we would consider a brother or sister an immediate relative. It's a defined term under immigration, and it relates to situations where a U.S. citizen is marrying someone, or that's a non-immigrant visa holder, or not a visa holder at all, or a situation where a child that is 21 or over is sponsoring their parents, right? So those are the kind of immediate relative categories that are applicable. Now, the reason those are the great categories, important categories, is because there's never a wait for these categories, in the sense that the green card is always current. And we're going to talk about that in a little bit of time, but that can save people a lot of time because unlike the immediate relative category, the preference-based categories, right now, every single one of those categories, there's a delay. And what that means is when you look at green cards, and this applies to employment-based green cards as well, that the government will only issue, or based on statute, only a certain number of green cards can be issued in each category each year. And once those are used up, then it's almost like a wait list that is formed. And some wait lists are very long. So for example, the category of US citizens sponsoring a sibling, there's at least a 14 or 15-year wait for that category, right? So that means that there's no real green card benefit that a person can get until that 14 or 15 years has passed. So that's something really to keep in mind because there are going to be long waits, and that's the one I just gave is probably the longest wait. But as I said, in every single preference category, there is a wait right now. So if a green card holder is marrying someone, that's a wait. If the parent is sponsoring a child over 21, that's a wait. And so those backlogs are very prominent. And as I said, that applies in the employment-based categories as well. And they're important because they have some implications in terms of what it is you can and can't do if there is a particular if there is a particular backlog. So now let's just talk about the process. And I think that it's important to kind of go over this process because it's relevant to both employment-based and family-based green card petitions. So there's always going to be either a two-step process or a three-step process. So the first step of the process, regardless of whether it's a two-step process or three-step process, is going to be an assessment of the objective criteria related to the green card category. So when I said that they're, in US, there's a list of categories, and if you're eligible, you can apply. So this is going to always look at the objectivity the objective factors of whether the person is eligible. So let's say if someone, a US citizen, is sponsoring their spouse, you're going to look at the marriage certificate. You're going to look to show that it's a bona fide marriage. If it's a sibling sponsoring, a US citizen sponsoring their sibling, you're going to look at the birth certificate to make sure that they're brother or sister. And the first step is always going to be that first step, objective step. And in a family-based case, it's going to be filing an I-130. In the employment-based case, it could be filing an I-140, it could be filing an I-526, depending on the type of petition. But it's always going to be the same. That the first step is that objective part. Now, once that objective part is approved, and sometimes it can be filed concurrently, you're either going to do one of two things. You're either going to file an adjustment status application, which is an I-485 petition, and that you can do if you're in the United States already. Or you're going to file consular processing. So if you file consular processing, that means the petition, the objective part of the petition, in this case, the I-130, has already been approved, and then you are going to process the green card from outside of the United States. Now, the reason the I-485 is really important and people love to file this, and the reason that we talk about whether the category is current, is because you can only file an I-485 application if A, you're in the United States, and B, the category is actually current, right? So now the benefit of that, so under the immediate relative category, the category is always going to be current. But let's say that someone was coming in under the preference-based category, and they, the example that I gave where it was a sibling, it would be 15 years before the category became current, and they wouldn't be able to file the I-485. But the benefit of filing the I-485 is that you're able to file for travel authorization and work authorization. So really, you're gonna, once the travel authorization and the work authorization has been approved, you're really gonna have all the benefits that you would have of having the green card, or most of the benefits of having the green card. Now, we do see that a lot of people move to the family-based green card based on having status in the United States. So it could be that they enter on an E2 or an L1 or whichever type of visa, and then they meet a US citizen and they get married. That happens often, and they adjust based on that category. It could be that they have a parent that's a US citizen and they're on a US based non-immigrant visa, and then time passes and they are able to adjust status or file for consular processing. But it is very common to see people move from visas to green cards based on the family base. So now let's take a look at the employment-based categories. So the first one is EB1, and this is extraordinary ability. So this is a category that you're going to look at if you meet one of the 8 criteria that are listed on this screen. So just picking one is that you command a high salary compared to your peers in the field, right? So that's basically because what this particular category is getting at is that the person has risen to the very top of their profession. So they say that having a high salary might indicate that. If you judge the work of others, that might indicate that. If you received different awards or recognition, that might indicate that. So you have to meet at least 3 of the 8 criteria. And then if you meet 3 of the 8 criteria, there's another subjective analysis that's done to see if you've risen to the top of your profession. And this is a way that people often move to, or sometimes move to a green card. Now, the non-immigrant visa category that we see people moving to this particular green card most is O1. So someone who's on an O1 because there's a non-immigrant visa category of O1 for extraordinary ability as well. And the criteria are very similar. So sometimes when people are on an O1, they might look to this category to get a green card. But sometimes they're in the United States on a different visa category and they have accumulated different awards or different recognition that over time, and they're able to apply for this category when they after time of being on a non-immigrant visa, and sometimes when it's not even an O. The other great thing about this petition is you can self-petition, so you don't need an employer. So that's a great thing to keep in mind. And this petition is available for entrepreneurs, and we have done that for entrepreneurs as well. So again, the process, it's this particular one is a 2-step process, and we will come to, actually, well, let me describe it now. I said it could be a 2 or 3-step process. So let's just go back to the family base for 1 second. And let's say the situation of the immediate relatives and someone sponsors someone for the spouse, the U.S. citizen sponsors the person. The 3rd step in that process, and this happens only in a few categories, the 3rd step in the process is that 2 years after having the green card, you have to prove that you're still married. And so what happens is in those instances, you get issued a conditional green card. And then the 3rd step in the process is having to remove those conditions. This particular category, EB1A, only has 2 steps. It's the subjective step, I-140, which is showing that you meet at least 3 of the 8 criteria that are listed on the screen. And then the 2nd step is going to be the same, where it's either I-485 if you're in the United States or consular processing. And then the same discussion that I mentioned earlier with respect to categories, whether they're current or not, apply with respect to whether you can apply for the I-485. And the way you can find out exactly what is current and what is not, there's something called a visa bulletin. It's a document issued by the immigration officials on a monthly basis. And the document shows exactly what changes every month because they have to calculate how many visas were used up, and it's a constant process of calculation. But they indicate in that document exactly what the numbers are. And once they publish that every month, then you'll be able to see whether or not your categories become current. Because what ends up happening is when you file the application, you get something called the priority date. So that's your place in line. Think of it as your place in line. And then the priority date, you're going to look at the visa bulletin to see if they're working on petitions with your priority date. So the next category that we do a lot of movement from people on non-immigrant visas to green cards is EB2. And we see people moving from E2, some people who started businesses, entrepreneurs moving from EB2 to national interest waiver, but others as well, sometimes H1B to national interest waiver. And what this particular category looks at, well, first, the reason it's called national interest waiver is because it's under the EB2 category, which we're going to talk about another item that's under the EB2 category. But what it is that's being waived is it's the labor certification. So the government has said that it's in the government's interest to protect U.S. jobs, and that's why they make people go through this labor certification, or make corporations go through this labor certification. But in this case, the labor certification is being waived. And they're saying the reason it's being waived is because the person is coming to the United States to do something that the United States feels is very important, right? So now the way we look at this is there's a case that was decided in 2017. It's called Danisar. And there are 3 things you have to prove. So you have to prove that the person's coming to the U.S. to do something that it has substantial merit and a national importance. Could be that it's jobs that are being created. It could be economic impact. It could be that, whatever it is that they are coming to do, the government says is important. Like, could be somebody coming to to work on cybersecurity, or it could be somebody that's an engineer that the government feels it's important, or what they might do is important. So that's kind of, you know, one of the criteria. Then the second is that the person is well positioned to advance the endeavor. And this one is going to look at things like, what's the person's track record? Have they done it before? What's their educational background? You know, are they really positioned to do this? Because the government won't just accept kind of someone saying, oh, well, I'm going to split the atom and say, yes, well, that's well, or do something that is extreme or exceptional in terms of national importance. But then prong two, you might get a check on prong one if you said that was what you're going to do. But then prong two, you wouldn't be able to, unless you were able to really provide evidence and documentation that you actually were well positioned to advance it. And then you have to provide evidence that shows that why should the government waive the labor certification? And often we can provide a lot of evidence from prong one and prong two, and then really anything else that is available related to the individual's, you know, whatever available related to the individual's importance to the United States. Now, the other thing to keep in mind is that there are threshold considerations with respect to EB2, and we do get a lot of people contacting us saying, well, I have exceptional ability because they've looked at the criteria, or I have a bachelor's degree plus 5 years experience and I'm eligible. Those are just the threshold requirements. So EB2, it's national interest waiver, but then it's also other company sponsoring you for a green card. But in order to be eligible for EB2 at all, you have to start with the threshold requirements and say, do you have an advanced degree? So that's master's degree or higher. And then, or do you have a bachelor's degree plus 5 years of experience? Or do you have, what's called exceptional ability? And the exceptional ability is going to be the 7 criteria that we indicate, we list out, the 7 criteria that we list out, and the criteria are going to be 7 criteria that we list out, and then the criteria are what we're going to then look at whether or not the person has met 3. But, and it's either or, so it's either advanced degree, master's or higher, or bachelor's plus 5, or exceptional ability. But again, we do separate webinars on EB1A, and also we do separate webinars on EB2, National Interest Waiver. National Interest Waiver, we have at least 2 a month, so you can definitely get more information on National Interest Waiver by either joining a future webinar or going to our YouTube channel and looking at our videos there. And that's all of the recordings from these webinars do get posted to our YouTube channel. So you'll be able to see old webinars as well as see this one on the YouTube channel. So the next category that we're going to talk about is EB2 and EB3. So what this has to do with is companies sponsoring someone for a green card. So usually people in this category might have a TN visa, or they might have an H-1B visa, and they are working for a company, and the company decides that they would like to sponsor them for a green card. And this is probably the most significant way that people get green cards in the United States, companies sponsoring for them. And what's happening here is that you're trying to show, or the regulation or the rules say that you have to show that the company could not find a qualified US worker. So in order to do that, there is a process that's been set up, which is a process that is artificial, and really it's working with the Department of Labor, and going through the Department of Labor and saying that you submitting documentation to show that you can't find a qualified US worker, but you actually have to prove it. You have to post ads for a job, get people to apply, interview them, rule them out that they're not qualified, etc. So it is quite a process, and it's a 3-step process that involves the Department of Labor. You first have to submit documentation related to the job, so showing them what the prevailing, and then the Department of Labor will come back and say, this is what the job should be paid. It's called the prevailing wage. You're developing a job description, and it is a job description for a firm, so it's minimum requirements only. It can't just be requirements that you like nice to haves. You have to go through the recruitment process. There are a lot of triggers that might generate an audit if you add in a foreign language requirement or requirements outside those normally required for that particular occupation. Like if you say, oh, well, it requires 15 years experience, and then the Department of Labor sees that for that occupation, normally it's just 3 or 4 years of experience, that can trigger an audit. And you do file that with the Department of Labor, and then once you get approved, then you file the with the I-140 and I-485. The I-140 in this particular type of application is probably the simpler part because it's the objective part. So if someone, for example, has a degree that they're using for a particular job, it might be easier to prove. And then again, the same considerations are going to be taken into account for filing the I-485 or doing consular processing, whether or not the category is current or not. Sometimes we also see people on E2s, for example, and E2, you can't sponsor someone from your family member or yourself. So, but sometimes what happens is their spouse may get a job somewhere else and he or she might get sponsorship from that company. And when that happens, the entire family, the spouse on the E2 plus the children under 21, all can join in the green card process. And the last employment-based category is EB5, and we have a lot of people moving from EB5 from many different visa categories. So sometimes it's from B, just people entering as a tourist and deciding to invest 800,000 or $1,050,000. A lot of E2s move to EB5, and those can be people who would be individuals who are have their own business, so they might want to just invest in their own business and apply for EB5, and others may decide that they want to invest in a regional center. So we really do have over a wide range of categories people applying for this. And what it is it gives you a green card if you invest $800,000 or $1,050,000 in a new commercial enterprise. And that's an enterprise that's been developed after 1990. And there are either regional centers, so it can be a more passive form of investment, or you can do direct investment where you are, the business is your business or investing in another business. The amount, different amounts, 800 versus 1,050,000, really depends on where you're investing. If you're investing in what's called a targeted employment area, so either a rural area or an area where the unemployment rate is 1.5 times the national average, then it's going to be the lower amount of 800,000. All the rest are going to be the higher amount. The investment, you do have to, unlike E2, as I said, a lot of people move from E2. Unlike E2, you do have to actually have, there are different criteria with respect to what can be included in the investment. So for example, E2, you can buy a business. EB5, no, it's a lot harder to qualify if you buy a business. The money that you invest in EB5 has to be linked to job creation. So, and also there are some expenditures like administrative fees that can't be included in EB5, which can be included for E2. So you do have to go through the process very thoroughly and with a qualified immigration attorney. The investment can be made over time. That's not a problem. It doesn't have to be all at once, but it does have to be all be made before you actually apply for the EB5. Also the investment, when you're thinking of E2, like let's say you have a business that made $1 million and then you said, okay, well, I'm just going to keep the money in the business and then I'm going to spend it next year. And because I spent $1 million, I qualify. Unfortunately, that's not the case. The money for EB5, you have to be in possession and control of the funds. The person investing has to be in possession and control of the funds and invest rather than retain earnings. And I went through already some of the differences between E2 and EB5. But one other big difference is E2 is country specific. You can only apply for E2 if you are from certain countries, about 80 countries that have treaties with the United States. But anyone can apply for an EB5. There may be different wait times just based on the number of visas that are issued for the actual green card, but anyone can apply for an EB5. The other big difference with EB5 is that the source of funds is very, very complex. It's treated more like an audit. So that's another big difference for E2. And it can only be an equity investment, so you can't loan a company money and then apply for EB5. The next big part of EB5 is job creation. So you have to create 10 full-time jobs, and the jobs have to be U.S. citizens or green card holders. So we do recommend that people engage and utilize E-Verify with a platform like that so that you can really check that whether or not the person is actually a green card holder or a citizen, because we have had situations where people have submitted documents that the employees have submitted documents that actually were fraudulent. So the objective part of the application is the I-526 or I-526E. The E is the one for the regional center. And then again, you go through the same analysis with the I-485 and consular processing. And then this is a three-step process because 2 years after getting the green card, you do have to file an I-829 petition. And that is something that is removing the conditions and really showing that you actually have met the requirement of creating the 10 full-time jobs. So a few other green card options that I wanted to touch on, the diversity lottery, just hooray, hooray. One of our diversity lottery applicants just got approved today, this morning when we got it. And it's, they have to be approved by the end of the month. So if not, it's lost. And this person's number was later in the process, but she was someone that was doing an E2 with us, and she applied for the diversity lottery and she won. We do, surprisingly, we have at least one of those a year, clients who win the diversity lottery. And so we did the application for her, and she was just approved today. Sometimes there are green cards that are issued based on humanitarian grounds as well. So it could help the police solve a crime, or if you're a victim of domestic violence, those can be areas. And then we do asylum can be another. And we do hope for immigration reform. But it's something I think that we need to, you're going to need an administration that's willing to commit to making those changes. Other considerations, so the timing, but some petitions take a long time, and especially if they're backlogged, then you really have to make sure that you are making sure that you're able to maintain your current status while you are waiting for either the category to become current or for the petition to be adjudicated. EB-5 petitions can sometimes take 4 to 5 years to be approved if the project is not in a rural area. And travel considerations, like if you file an I-485, you do have to wait until the green card, the travel authorization has been approved before you travel. So sometimes people can't do that, so that might force them to maybe have to do consular processing instead of the normal option, or instead of adjustment status. And dual intent, if some visas don't have this issue, if you have H-1B or L-1, then you can come and go as you apply for an I-485. But it's but most visa categories do. And then sometimes people do pursue parallel green card strategies. We have one client right now that comes to mind where he's doing EB-5, but he's also perhaps eligible for NIW, and so we're doing both applications for him. And planning is really the key, I think, with all of these things. So yeah, that was all the prepared remarks, and so we're just going to take questions. So I see one question here. If applying for a green card through an adjustment status, what happens to your application if your visa expires and you must leave the US? So that's a great question, and it really gets to what I was just, the last slide that I just went over, is that you really have to look at timing, and you really want to make sure that you are giving yourself enough time when you're applying for a green card so that you maybe don't have to renew your non-immigrant visa. Because if you have an I-485 pending, you're not going to be able to renew your non-immigrant visa. If you're in the US on an E2, you can still extend the visa in the US. There's regulation that permits you to do that. But you do have to kind of plan everything out, because if you have an adjustment status petition pending, and you always have to make sure that you're going to have a basis to stay in the United States during that time, or you're going to work in the United States. The fact that you have an adjustment status petition pending means you're in a period of authorized stay, so you don't have to leave. Even if your I-94 runs out, you don't have to leave. But what can happen is your underlying work authorization may not be valid. So in order to be able to work, you would need the work authorization approved from the EAD. So I think that's it. I don't see any more questions in the Q&A. I see one more here. Okay. What are the options with an approved EB2 national interest, but priority date not current, and my STEM OPT ends soon? How do I maintain my status? Why did the EB2 visa bulletin didn't move at all? Okay, so unfortunately there aren't a lot of options. Depending on when your STEM OPT ends, you might be able to apply for an H-1B if you have time, like for next year, and maybe but it looks like that's not going to. It looks like that's not going to be not going to be an option. It could be that if you're just trying to bridge a little bit of time, then maybe you wouldn't be able to work, but you could apply for change to a B2 and maybe just do tourism for 6 months, and then if the category becomes current, then you can file the I-485 during that time. The other kind of thing is there's something called 245K, which gives you 6 months. So even if your status runs out and you are in the United States and don't have status for a 6-month period, then you can elect something that's called 245K, which means you can still file the adjustment status application. But definitely work very closely with an immigration lawyer to understand that. Can citizens of all countries apply for a diversity lottery? No. So you have to look at the diversity lottery rules, and they change the countries that can apply every year because they're looking at which countries have a certain number of immigration to the United States. So, for example, I don't think Canadians can apply, for example. But then there are other rules that if you have a spouse or if you were born in another country that you might be able to apply. But it's not blanket. And you apply in October, so you should definitely look at the rules because they're probably out by now with respect to that. Or they'll be out soon. Can you apply for a loan for EB-5 source of funds? So yes, you can apply for a loan for EB-5 source of funds. The loan can't be secured against the security can't be the business. So it can be your personal security or unsecured. If it's your personal security, they will normally ask for documentation related to where you got the money for the personal security as well. Chef with 15 years experience, Canadian bachelor's degree, can I be eligible for a category like EB2 or O1? So I don't know. You'd have to set up a consultation. It's not enough information to see whether you'd be eligible or not. How will I get the B2 with an approved I-140? Well, I mean, just the I-140 is approved. So you could say I'm staying for tourism and apply for a if you have valid F status and you do a change of status at the end of your F from filing an I-539 form, that would be fine. You have an I-140 filed, not an I-485. So. But filing the B, I think speak to an immigration lawyer because there may be implications with respect to filing the B in the sense of the attestation you're making related to not doing an adjustment of status, right? So that's something to talk to a lawyer about because it's definitely very nuanced. What is the success rate or approval for green cards having a TN? So the people on a TN, get green cards in multiple different ways. So I don't know what the approval rate is. I own digital marketing, but getting a green card is an objective process. It's not, it's not that subjective. If the company's sponsoring you for green card, it's pretty objective. I own a digital marketing company in Canada. I'd like to stay in the US during the winter. Can I work in the US while there if I only no? So you need a visa to do that. Yeah, you definitely need a visa to spend, for example, 6 months in the United States working remotely. You would need a visa. Food truck can be investment of 75. Will that be sufficient for each? So this isn't an E2 webinar, but we do have a lot of those. So definitely encourage you to sign up for that. But 75,000 could definitely be sufficient for an E2 visa. So that's something to consider. Great. So yeah, in the end, it looked like there were quite a few questions. So that's fantastic. And there's one more question here. If I apply for a loan for an EB-5 secured against your personal property, does the loan have to be from your home country? No, so the loan can be from anywhere. The money for EB-5 does not have to come from your home country. So the money can come from anywhere, as long as you can prove that it came from a legitimate source. So, and definitely for those looking at EB-5, I definitely encourage you to set up a consultation. We'd be happy to look. If I'm born in Indian, but I'm Australian citizen, can I still apply for diversity lottery? So again, please look at the diversity lottery rules. I haven't memorized the countries that are eligible from the ones that are not, and even if I memorize them, they change every year. So when the rules come out for the October filing, they will indicate which countries, and the rules are quite. The instructions also are very straightforward, so they will also indicate instances like what applies when where you're born, if you have a spouse, where you can elect and things like that. So definitely take a look at the rules. If the new rules aren't out, then you can definitely look at the rules from last year and see. Perfect. So great. So that's fantastic. And as I said, we'll send out information to you, the actual video link, the consultation link, the guides, the YouTube channel, and the PowerPoint. And definitely, if you have questions, feel free to set up a consultation. And it was great speaking and a lot of great questions, which is fantastic. Thank you very much.